Conversations between attorneys and clients are absolutely confidential. That's what a Long Island lawyer believed until a prosecutor handed him a recording of one of his clients calling his office. Are prosecutors ignoring the attorney-client privilege? Tonight, the I-Team's Chris Glorioso investigates.
It is a basic tenet of our legal system, the right to talk with your attorney without fear your words will be used against you. So when an inmate called his lawyer's office from jail and the prosecutor listened in, it raised questions about attorney-client privilege.
Attorney-client privilege is so important because it's one of the underpinnings of our system.
Stephen Raiser has been a criminal defense lawyer for 8 years. In law school, he learned the attorney-client privilege is a given. Prosecutors are not supposed to listen in on discussions between defendants and their lawyers. That's why Raiser was alarmed when an assistant DA in Nassau County tried to introduce as evidence a recording of his client on the phone with his law office.
The fact is, there's an attorney-client privilege phone call. The district attorney is not supposed to then use those communications. It's the same thing if somebody went in to speak to their priest.
The case in question involved a defendant accused of intimidating a witness, and ultimately the charge against him was dismissed. But the DA's office told the I-Team this case presented a number of issues regarding the attorney-client privilege and exceptions that apply to that privilege.
Listening to an attorney-client privilege conversation is absolutely, that's not to be done.
Toro College law professor Richard Klein says attorney-client privilege is nearly absolute. And he's skeptical there could be a good reason for a prosecutor to listen in.
That's a serious violation that took place. And I think that we have to make sure that occurrences like that don't happen.
But another legal scholar disagrees. Fordham law professor Jim Cohen said neither inmates nor their lawyers should count on privacy when it comes to calls made from jail. That's because signs posted near jailhouse phones warn inmates that their calls are recorded.
The government, whether it be federal or state, takes the position that you waived it. You knew. We told you we would be listening, and we told you that we would be using the contents of the conversation. So you really have no complaint at all.
In a letter responding to Stephen Raiser, the DA's office insisted not all conversations with an attorney or his employees are privileged, and the privilege will not be recognized if the purpose of the communication was to further an ongoing crime. Raiser says if prosecutors believe an inmate is committing a crime by calling his law office, they should have to go to a judge before listening in.
What is the policy of the district attorney's office? Why are they listening to all these tapes without getting any input from the court? Why is there no oversight?
The Nassau County Jail has a computer system designed to block the recording of calls from inmates to their attorneys' offices. We reached out to the sheriff's department to find out how and why this phone call was recorded anyway. We did not get a response. The district attorney's office says when it does receive a recording in error, they stop listening as soon as they realize it's privileged. Reporting from the newsroom, Chris Glorioso, News 4 New York.